All right, good morning again, and thank you all for joining us for this discussion of bail reform efforts across the United States. This panel discussion will cover the status of bail reform in several states and the lessons that can be applied as other jurisdictions across the country move away from money bail-based systems. I want to give a quick thanks to Annie McGowan of the Civic Federation staff who organized this panel and did a magnificent job. It is now my pleasure to introduce our esteemed moderator. In order to jump right into the discussion, we will provide short introductions here. For more detailed bios and other supporting materials, you can find the conference webpages linked to in the brochure, which drops down from the top of your screen when you're not experiencing broadcast like we have right now. Make sure you right-click on those links in order to open them up in a new. Paula Wolf currently serves as policy advisor for the Illinois Justice Project. She has served in leadership positions for the Justice Project and its since 2000. Paula previously led Governor State University and worked for or advised multiple Illinois governors. She serves as vice president of the Chicago Police Board. Illinois Supreme Court Chief Justice Ann Burke was first appointed as a judge in 1987 and served on the state's highest court since 2006. She became Chief Justice of the Illinois Supreme Court in 2019. Judge Glenn Grant has served as director of the New Jersey Administrative Office of the Court since 2008, where he provides day-to-day management of the court system. Grant first joined the Superior Court bench in 1998 and previously served as counsel and administrator of the city of Newark. Insha Rahman is the vice president of advocacy and partnerships for the Vera Institute of Justice, where she works in the areas of prosecutorial reform, bail, and decarceration. She has previously served as a public defender and is a nationally recognized expert on bail. Nick Hudson is a policy and advocacy strategist for the ACLU of Texas. His team focuses on criminal legal reform and police reform at the state and local level. Prior to joining the ACLU, he was a political strategist and state director at Texas for Marriage. Thank you to all of our expert guests for joining us this morning to discuss bail reform efforts. We are very much looking forward to this conversation. We'd like to let everybody in the audience know that you can submit questions either by using the chat function or the raise your hand function. To ask questions via the chat, click on floor in the lower right-hand corner of your screen, and then scroll down and type your question. This will send the question to everybody in the ballroom. To ask a question via the raise hand function, click the hand symbol at the top of your screen. This will alert staff that you'd like to ask a question, and we will add you to the video chat. Now I'm going to hand it over to our moderator, Paula Wolf.
Sarah, thank you very much, and thank you for the Civic Federation for hosting us and putting this together. Just a little coda. When we are finished with some questions, we will, among our panel, we will then take questions from the audience. So feel free to put them in the chat, but you'll see when we're about 3/4 of the way through our time, we'll ask you to raise your hands for the other questions so that we can keep the flow of the panel going. So I'm delighted that we are actually talking about implementation. It is the least thought about, talked about, observed part of the policy process. I once taught a seminar with somebody who was the Svengali of Chicago politics, so you can imagine how nefarious and cynical he was. And the name of the course was Developing and Implementing Policy. And he said, don't say implementing, say executing. And I said, well, why would you talk about executing? And he said, well, it has two meanings. It means to implement, but it also means to kill. So lots of policies get passed, they get incorporated into law, and then during the implementation process, they magically get killed. So we're going to talk about bond reform here and how we're going to make sure that it doesn't get killed and observe how it hasn't gotten killed in a lot of jurisdictions. So I want to thank our panelists very much for coming. We're going to look at how the implementation is underway in some jurisdictions and how it's just starting in others, what kinds of challenges and barriers and lessons can be learned from places that have already moved toward bond reform. So we're going to start out, excuse me, with a general question. We want to really find out this current state of bond reform in each of the jurisdictions where our panelists come from. So I'd like to start with Justice Burke, who knows all. If she would talk to us a little bit about the bond reform that passed the Illinois General Assembly in January of this year, and it then was signed by the governor in February. And that big law includes the Pretrial Fairness Act, which ends cash bond in 2023, and creates a new process for determining whether somebody is released pretrial or held. And we want to ask you to talk to us a little bit about the key changes and then the responsibility that the Supreme Court has in actually implementing this pre-trial release system and how that's going. So thank you, Justice Burke, for joining us.
Well, thank you, Paula, and I'm honored to be with the distinguished members of this panel, and I thank the Civic Federation and the GRA for doing this. I think it's very important to have this kind of a program together, and I'm anxious to learn from everyone. Well, besides, as you said, Paul, creating a presumption that the defendant is entitled to release on personal recognizance, the conditions on release may be only imposed when necessary to assure the defendant's appearance in court or to assure that the defendant does not commit new criminal offenses. It also defines preventative detention, who may be detained, and the requirements and the procedures for detaining the defendant. In addition, it strengthens the role of the indigent defense in detention decision making, amends the code of criminal procedure regarding the conditions of release, and defines willful flight from prosecution, creates a pretrial practice data oversight board under the authority of the administrative offices of the Illinois courts, our administrative office. So the Supreme Court is overseeing this data oversight board, requires law enforcement to issue a citation in lieu of custodial arrest for traffic offenses and other misdemeanor and petty offenses with appearance in court within 21 days, adds additional parameters during the pretrial stage, defines procedure for violations of pretrial release, and increases rights afforded to victims. The Illinois Supreme Court has kept its finger on the pulse of bond reform since 2015, as well as the Civic Federation, the Civic Consulting Organization, Cook County Board, the Justice Advisory Council, and our other justice stakeholders to look at bond reform. But in 2017, the Illinois Supreme Court, we formed a commission on pretrial service practices. The work of this task force culminated with a comprehensive final report with recommendations issued in April 2020. Now, after the court approved the report, it was released in May 2020. The commission has been reestablished as the Illinois Supreme Court Commission on Pretrial Practices Implementation Task Force, not to kill, but to implement the task force to act on the report's recommendations. The court has been familiar with many of the provisions with the Safety Act because the legislative subcommittee of the task force studied the recommendations of the commission's final report, and this information provided from the Illinois Courts Commission, not Courts Commission, but task force, has been used in the legislation, and it's cross-pollinated with people from the legislature and the Supreme Court's administrative office, as well as others, to make sure we collaborated on the final act. As a result, most of the report's legislative recommendations from the final report are included in the Safety Act, and now the Pretrial Fairness Act has been enacted. The task force is continuing to work on the steps that must be taken to implement. The task force reports directly to the Supreme Court and provides the recommendations for the changes for our court rules and other changes, such as overuse of confinement during the pretrial stage, disproportionate minority confinement during the pretrial stage, improved due process by allowing equal access to defense counsel in preparation for trial. If defendants plead guilty solely to be freed on custody, whether that is occurring, creation of uniform statewide pretrial best practices, limitation on the conditions placed on the released defendants who are presumed innocent. And all our work has directly been in collaboration with the many stakeholders, the legislators, and their staffs, and continues to remain so. So it isn't just the matter of the Supreme Court working on this or other people in silos. We're all working and collaborating together in Illinois.
Thank you. And I would make an editorial comment. Justice Burke talks about having the finger on the pulse of this project. I would say she had a gentle hand on the back of those who were interested in bond reform moving it forward. I would say it was more than just fingers on the pulse. Thank you. So let's turn to Judge Grant. So New Jersey implemented the criminal justice reform beginning in January of 2017 that we understand has proved successful in decreasing the number of people in jail without negatively affecting public safety. Could you talk a little bit about how the pretrial release system works and the results in New Jersey after 4 years into its implementation?
So our journey really is very comparable to what Illinois is currently trying to do. New Jersey has been involved in an analysis of criminal justice reform for probably about 2 decades. Beginning in 2012, there was a study which found that 1 out of 8 defendants were being held on bail, cash bond, for amounts of $2,500 or less. New Jersey at the time did not have a preventive detention constitutional authorization. And so our Chief Justice, Stuart Rabner, convened a meeting of all of the critical stakeholders, prosecutors, attorney general, public defenders, private counsel, wardens, and others, to come up with a comprehensive series of recommendations. There were 18 recommendations that were established by the committee. That was in late 2013. That was presented to the legislature. And then in 2014, the legislature did 2 things. One was to enact a proposed ballot question, which would allow for a constitutional amendment to allow for individuals to be detained pre-trial. That constitutional amendment was passed in November of 2014, which allowed for the detention of high-risk individuals. They also enacted statutory changes that were, for the most part, very comprehensive based upon recommendations of the Chief Justice Committee. Some of those changes included a presumption of pretrial release for most defendants. There was a hierarchy of release conditions. We did not eliminate bail, but bail was one of the last options before incarceration. In the statute, there is a requirement that we use the evidence-based tool to submit recommendations to the trial court with regards to a person's release status. The statute also created a prosecutorial pretrial detention process. It did was to create a very robust adversarial process where prosecutors have to file a motion to pretrial detain an individual. That motion is then heard before a judge, defense counsel, and the judge has to decide by clear and convincing evidence that that individual should be detained either based on the possibility of recidivism or risk of flight. We created specific time frames for the person, if they were pretrial detained, for the person to be indicted in 90 days, and then another 170 days thereafter for the individual to move to trial. There were 13 exclusionary categories which would allow those timeframes to be extended, if you will. Things such as a motion by the defense to suppress a competency hearing, all are justifications, some of the justifications for why the timeframes could be extended. They also created within the Administrative Office of the Court a pretrial service component. We did not have one before that. And that required the AOC, our Administrative Office of the Court, to create a pretrial service unit across our 21 counties designed to assist individuals in meeting their trial obligations, their court obligations, and hopefully staying out of trouble. We also authorized a very robust technological authorization that allowed for us to partner with the John and Laurel Arnold Foundation to create an automated risk screening tool that is provided to the court, the defense, and prosecutor and judge within a matter of seconds. And that became the foundation for our program. We also expanded our technology infrastructure to build in alerts to the defendants. We built an automated system to deal with electronic monitoring, and we then designed a system that would let all of the parties know, for example, when the 90 days on indictment was coming up, when the 170 days on trial were coming up. And there's an outlier that if within 2 years you're not able to proceed with the trial, that person has to have their release status re-examined. So we were able to do that with funding through our filing fees. This was not an exact statutory enactment. And over the years, I was constantly reminding the legislature and the governor's office about the challenges of funding an ongoing operation based upon filing fees. Finally, in 2019, they decided to fund, or they agreed to fund, the cost of our operations as part of the overall state budget, and we were successful with that. The results have been fairly positive. Bail, while it's still in our hierarchy, is used very limited. In 2019, for example, we had 44,000 people who were sent to our county jails. I'm sorry, one of the other responsibilities under statute was anybody that was sent to our county jails had to be processed within 48 hours unless the prosecutor made a application to detain that individual. And out of those 44,000 individuals, only 4 had bails. And then last year, in 2020, we only had 5 people that had bails. And so we've essentially eliminated bail from our option. The jail population pre-COVID has been reduced substantially. As I said, we've been at this effort for a long time. The 2012 jail population was over 15,000 individuals. In 2019, that number was under 8,000. And equally important, there's been a change in the composition of the individuals that are pretrial detained now. 65% of the people that are pretrial detained in our county jails are now facing first or second degree charges, the highest degree charges in our state. And so we flipped that. And the 12% population of people being in there for low bails was reduced from 12% to 2.4% in our last year of counting. So we really have shifted the paradigm, if you will, for how people are pretrial detained in our system, trying to balance those competing needs of reducing criminality or the possibility of criminality, but also living up to those constitutional mandates of the presumption of innocence and providing people with an opportunity not to lose their home, not to lose their job, not to lose their custody of their children, all because of the negative consequences of having a cash bail system. So overall, we believe that it's been very successful. We're still efforting. We still have a lot more work to do. We're still partnering, but we think we've got a success that we can sell to the rest of the country.
We're just about to turn to Incha, but I have one question before we get to New York. Do you have a bail bond system in New Jersey?
Yeah, we did. It's essentially eliminated now, but I was sued multiple times by the bail bond industry, so I know it very personally.
Okay.
Yes, we do have.
Okay, great. So just as the bumps in the road to implementation. So New York State enacted bail reform in 2020 in January and then rolled it back. And can you talk a little bit about what's happened in New York State and the status of where things are now? Thank you.
Sure. And I echo Chief Justice Burke's gratitude for this conversation, because it's great to get to hear across the country what's happening, both with bail in implementation as well as places where really we're on the cusp of either really good things happening with bail reform or bad things happening, as Nick will speak about in Texas. So I'm grateful for just the array in this panel, because I think it's really helpful to our audience, and certainly to me as a practitioner and policy person who works on bail reform across the country. So Paul, I want to take issue with one thing that you framed in terms of New York and bail reform. The entire statute didn't get rolled back. Some of it did, and I will talk a little bit about both the policy and the politics. And one thing I want to do before I start to talk about New York is just actually zoom back for a quick second, so indulge me, in just sort of where we are in terms of bail reform in this country. Until New Jersey passed bail reform in 2014 and it went into effect in 2017, literally no jurisdiction in this country had wholesale across an entire state or large locality actually engaged in bail reform of any sort since 1991, when Washington, D.C. was the first jurisdiction to move away from using money bail. And what we've learned in those intervening 15 years, and then in the past 5 years since New Jersey took on this courageous and really effective effort on bail reform, is getting rid of money bail is important for sure, but so is decarceration and actually having fewer people behind bars. And you saw that very clearly in how New Jersey approached bail reform, that they looked very carefully at who was behind bars and who could we, in the interest of public safety, no longer incarcerate. And that was the lesson learned from places like DC that passed bail reform but didn't necessarily lead to decarceration, and other jurisdictions that had at the local level engaged in bail reform efforts and perhaps reduced the use of money bail, but preventative detention or pretrial detention actually remained the same or even went up. So I say that first to say there's a really important historical arc here, and where we are right now when it comes to criminal justice reform and specifically bail is eliminating the role of money and profit, which we've seen New Jersey, and fingers crossed when Illinois goes into effect, we'll see that have been done. And that's a real step forward in this country against the bail bond industry. But secondly, to decarcerate, to make sure that there are fewer people behind bars. And Judge Grant, you threw out the number that I use often when I talk about New Jersey, which is that now 5 years later, there's 45% fewer people behind bars as a result of pretrial reform. And that is really remarkable and should be heralded, because at the same time that the jail population has decarcerated, public safety has been maintained. In fact, overall crime rates in New Jersey are lower. Violent crime is lower by 18% than before bail reform was enacted. And those are positive figures that show us we can decarcerate and maintain public safety. But the third most important thing is racial disparities. We know that there are gross racial disparities in the pretrial system and who remains incarcerated. And Judge Grant, I don't think I'm speaking out of turn in saying that's still a struggle for New Jersey, where before bail reform, the jail population was about 54% Black. After bail reform, even though there are far fewer people incarcerated, the jail population is still about 54% Black. And so there's more work to be done there. And New York is seeing the same challenge. We have decarcerated, but we have not made an impact on racial disparities. And finally, the other question is, so if we remove the use of money bail and we incarcerate less, what is the system that we build out for pretrial supervision and services in its stead that is not overly punitive, but that supports people in returning to court and maintaining public safety? And I would say that there's still a lot of work in progress to be done to get that piece of bail reform right. So I just think that context is helpful as we hear from New Jersey, Illinois, Texas, New York, what actually got passed in terms of policy, and then what's happening in practice with implementation. So New York passed bail reform in 2019, and it went into effect in 2020. And I want to highlight how New York's bail reform came to pass and how it's distinct in some ways from what New Jersey passed and what Illinois just passed. First and foremost, there wasn't in New York, in terms of the politics, the kind of big tent approach that we saw in New Jersey, where Chief Justice Rabner, the Supreme Court justice in New Jersey, really led the effort. And, sort of everyone from the Attorney General's office to the Public Defender's office to even some members of law enforcement were really on board. And I believe there was a similar sort of big tent approach in Illinois, as evidenced by the fact that you are here, Justice Burke, speaking so glowingly of the good work that your state has done and that you have helped to lead. In New York, bail reform was really passed by legislators. Up in Albany, it was driven by the governor's office that introduced a bail reform package in the budget and then was negotiated against by the legislature and came to pass in April 2019. One really interesting political point was this idea of public safety and risk to public safety being a basis for setting bail or pretrial detention. New York stands alone, is distinct from every other state in that judges are not supposed to set bail or incarcerate based on a risk to public safety, only at the risk of failure to appear. I was a longtime public defender before coming to Vera. I've practiced in the courts, and I know that judges set bail anyway because they are considering public safety, but at least as a political negotiation point, that actually stayed out of the law, and it's why money bail essentially stayed in. It was the trade-off to say, well, we don't want to allow for the introduction of risk to public safety to be considered, so therefore we can't eliminate money bail entirely. I think that's an unfortunate trade-off, but it is one of politics, not of policy. all of us would agree that leaving money bail for the most serious offenses is really an end run around public safety and being concerned about public safety. So I just want to point out why that is, because people often sort of ask what happened there. And that's really, it was about the politics, not necessarily policy, that compromise was made. But in terms of the law itself, here's 5 distinct characteristics of New York's bail reform that really built upon the successes we'd seen in New Jersey, and I think helped to lay the groundwork for some of the really important provisions we saw in Illinois. First and foremost,
I'm sorry, Ange, I'm going to ask you to go pretty quickly. I'm afraid
Sure.
we're out of time.
Of course, yeah. So here are the 5 things. I think one that's really important is New York went from not only a presumption of release to a mandate of release for the vast majority of offenses. Over 85% of arrests would be guaranteed release, and the discretion that remained for judges is about what conditions of release could be imposed. In terms of conditions, it limited the use of electronic monitoring to only felonies and more serious domestic violence cases, which is a difference, again, between what we've seen in other parts of the country that had enacted bail reform. And then, since money bail was left in, an important innovation was that judges are required to consider ability to pay and actually set forms of bail that are more affordable, which was a way of actually strangling the bail bond industry without having the might to actually eliminate them outright. So again, I think it's interesting to see how the different policy pieces of the law were really driven by the politics. And what we know from New York's bail reform, when it went into effect, it actually decarcerated by 45%, literally within months. But there was tons of bad press. And I would say it's the first time we saw a really sophisticated backlash effort that was driven by the bail bond industry, supported by law enforcement officials here in New York, the Sheriff's Association, various police unions, that led to just an outcry. We saw literally in one poll that support for bail reform before it went into effect was up in the high 50s. And after the law had gone into effect, we saw a couple of bad media articles. Support for it among voters had plummeted to under 30%. That's just a remarkable drop. And it was really fueled by the media attention around a handful of negative cases, which resulted in some limited rollbacks to the law. And the result of it has basically been a 15% increase in pretrial incarceration since the law originally went into effect in its original form. So not rolled back entirely by any means, but certainly curtailed. More cases were added to the money bail bucket, which is what resulted in that 15% uptick in incarceration since the law went into effect. Sorry, Paula, for taking so long, but I think it's interesting because in some ways, New York's bail reform is very distinct from New Jersey, and then also what Illinois has just passed. And I think the politics of it are particularly interesting because it's gotten a lot of press nationally for being a disaster, when in fact you look at the numbers, it isn't. But in terms of the press, it certainly has not gone well.
Well, thank you for the clarification. That was very helpful. So Nick, we're going to turn to you and ask you what happened in Harris County and the next steps that you see there. Provide us with an overview of what was proposed and where you stand.
Sure. So at the outset, I just want to say VERA Institute has been very engaged in Harris County. And so in a lot of ways, they should be far more qualified to talk about what happened in Harris County than me, but I'll do my best to give a brief overview and talk about Texas. I want to start, though, I know that there are some folks who know the system really well, but I want to start by talking about a man named Preston Cheney. He was a 64-year-old who was booked into the Harris County Jail in April of last year. And he was accused of stealing lawn equipment and frozen meat. And after he was booked, the magistrate set his bail amount at $1,000. And if he had $100, he could have posted bail and walked free. And instead, he was held in the Harris County Jail for 3.5 months. He got COVID, and then he died in August. And I wanted to just root us in the humanity as we kind of proceed in this conversation, because there are hundreds of people who have died across the country due to COVID, and almost 100, I think, who have died here in Texas. And on any given day, there are about 40,000 people detained pre-trial. There are vast racial disparities in the number of people, in the people who are detained pre-trial and in our jails. And what we're seeing in Texas with this legislation is legislation that leaves people like Mr. Cheney behind and largely allows wealth-based detention to continue. I want to just say, I'll touch on Harris and then I'll go into the state stuff. In 2016, a lawsuit was filed in Harris County. It is the biggest jurisdiction in Texas. It's where Houston is, and it's bigger than 26 states, Harris County is. And the judge, the lawsuit challenged unconstitutional wealth-based detention. The judge ruled that there were tens of thousands of constitutional violations under the county's money bail system, and it was creating irreparable harm. And the criminal courts of law approved a landmark settlement that required the vast majority of people accused of misdemeanors to be automatically released, robust procedural protections, a fair process for people who were still allowed to have money bail assessed on misdemeanors. People were provided attorneys at bail hearings and social workers and text reminders to get back to court. And they also insisted upon robust data collection, which I think we'll talk about a little later. But before the lawsuit, more than 90% of people accused of misdemeanors had money bail set. Now that number is less than 15%. So they have really significantly, almost eliminated money bail in the vast majority of misdemeanor cases in Texas. And I think that I want to also tie Harris County to Harris County is really driving the conversation about pretrial reform in Texas in a lot of ways. I think what we were seeing is really two responses to the litigation and in Texas, and especially in Harris County. And I think one response is from the courts and the court administrators who are eyeing a potential future where money bail goes away, and they're trying to devise a system to sort people and make more rational decisions about who we keep in jail. And then I think the other response, and this sort of mirrors what happened in New York, we're seeing the bail industry get very organized because they are facing an existential threat, and they are doing what they can to protect their bottom line. And they are exploiting tragedies and partnering with law enforcement to stoke fear and confuse lawmakers and leverage that fear and confusion to really protect themselves. And so I'll talk about a few of the key provisions in the legislation that do that. I just want to say that I think the legislation we see is really a combination of a weird mix of the court administrator's response and the bail industry response. And it's not anything that would actually meaningfully improve public safety. That's what's so disappointing. We are missing this big opportunity to actually address the big problems in our bail system. And it's not because people like Chief Justice Hecht in Texas, who's been very good on this issue, doesn't understand it. It's just that we've got some powerful political influences and social dynamics in our state going on right now. And so, overall, the legislation doesn't do very much to meaningfully improve safety. There are some provisions which are relatively unobjectionable or potentially even positive. For example, it requires more judicial training and least restrictive conditions when setting bail. But it also has some really overwhelmingly bad areas of concern. So first, it would require more people who are accused of some serious offenses to pay money bail. So it actually takes away the option of release on non-monetary conditions for huge swaths of Texans if they're accused of offenses like assault, if you're in a bar fight. And then a second thing that really kind of is a bail industry kind of attack as far as we see it is the attack on charitable bail organizations. They're trying to limit who charitable bail organizations can bail out, and also allow suspension of their operations altogether if they make clerical errors or paperwork errors. And then the third thing that I just want to focus on is what our Fifth Circuit has said. And our Fifth Circuit is a conservative court. It sort of half-heartedly tries to implement some of the procedural due process protections the Fifth Circuit said are required if you are going to have a bail schedule. But it really actually creates a really burdensome structure for defendants that we don't think is actually going to be a real path to meaningful reductions in pretrial detention. So we are, I think what we are doing in Texas is just trying to mitigate the harm this bill causes. We think something is likely to pass. And so we're really trying to address those main provisions. And then I think just the last point I just want to make is I'm sure that a lot of you have seen that there's news about Democrats in Texas who are in the House leaving the state. They're breaking quorum so the legislature can't do work. The main reason for that is the voting legislation, but some lawmakers are also very concerned about this bail legislation too. And so that's another reason that some of the lawmakers have left the state. There was a kind of a parade of horribles as far as they are concerned on the legislative agenda. And for that reason, they left the state. And so what I think is likely to happen, we'll see folks come back around August 8th, and then we're going to see where we can make a difference on this legislation and see where we can mitigate harm and sort of engage in longer term work in Texas while we try to stop a backslide.
I saw your governor said he was going to arrest them when they come back. I hope they don't have to pay cash bond to get out when they get arrested and put in jail. So we've kind of transitioned into the second question we were going to ask, and this is going to be lightning round. We're going to give 2 minutes to anybody who wants to speak. We want to hear a little bit more, or for those of you who haven't had a chance to talk about it, your perspective on how we educate and train people to achieve consensus and buy-in from the stakeholders who might be resistant. So Justice Burke, would you like to start? How are we handling the people who might be resistant?
Well, Judge Hecht from Texas and Judge Grant and myself, all being judges, maybe have a leg up on some of this ability to ask people to be trained on things. And fortunately, the legislators really did work with our judicial administrative office, and that we still are working on everything. So there's a lot of collaboration. Everybody wants this to work, but the problem in Illinois is the goal of creating a uniform pretrial structure and operation through this state is really kind of challenging by the size of our state and the diversity of our state. We have 102 counties, and individually, these 102 counties actually pay for or fund a portion of the justice employees in their county as well as the county courthouse. So historically, we didn't have much opportunity pre-COVID to get a lot of buy-in for a lot of things. So in addition to the 102 counties, we have 5 judicial districts, which again, our legislature and the midnight oil on June 3rd actually redistricted our entire justice system throughout the state, changed all the appellate judicial districts, and some of the circuits are changed. So right now, besides having to implement things like this free trial, we have to change the makeup of our judicial districts. But I wanted to mention too that our research has revealed that 52% of the counties in Illinois lack any type of pretrial service functions. 24% operate under limited functions, and 24% have established some programs. So we have a limited county funding. So we have to be able to get some state funding here. The other issues that impact the Safety Act are the unfunded mandate of it. And it looks like there's about, in terms of bond, one of the figures that is being bashed around is $86 million less because of the bond that the court would be able to, the clerks would get a portion of that, and other entities would get a portion. So they have to make up that $86 million.
Okay, I'm going to be rude, and I don't have a gavel, but interrupt you. And is there any other quick thing you want to say, or could?
Well, I still have to say that the task force, the implementation task force, is working very hard. All the stakeholders are involved, everybody's involved, and I hope that we are going to be successful. It's going to be more than hope. We're going to be successful. So that's all I can say. Okay.
And thank you to the Civic Federation, who I think has done some of the research about the Sundays.
Yes, they did, for sure.
Call out to them. Judge Grant, is there anything that we haven't had an opportunity to talk about that you would like to mention in terms of helping people come together to continue to support the work in New Jersey? I think you're on mute. There you go.
Communication and outreach, and as Chief Justice Burke was talking about, the power of the road. New Jersey's version of this program was like a political campaign. I spoke at religious organizations. We had meetings with all kinds of people, law enforcement organizations, counties, and the collaboration that is required of this is ongoing. We're still meeting with both internal and external stakeholders promoting this program, because when you look at the bail reform, cash bond reform, if you will, it's existed in our country for about 3 centuries. And you're talking about something, even New Jersey just has shallow roots entered into the ground right now. So we will continue to focus on how do I bring those collaborations and those partnerships. It is an ongoing effort. It would be just like you were running for president or anything of that nature, a political campaign. You got to think about all of the media. I met with editorial boards of our largest papers. All those kinds of strategies need to take place because, as was correctly highlighted by Mr. Hudson, the bail bondsmen have not went away. One of the unfortunate things, if you allow people to frame the question, will be to compare the perfect against the old bail system. Under the old bail system, we had people reoffending and committing horrible offenses. And we will have those incidents under the new pretrial release system. But as Ms. Rahman provided, the demonstrated success of the program is you have a better effect on the lives of the people who come in contact with our system. And the impact to the crime rate, the impact to victims is comparable to, because it's not perfect, it's comparable to what existed under the old bail system.
Take about 3 more minutes before we have questions from the audience. If anybody wants to put a question in the chat or put your hand up, and Annie is going to help us to handle those. So let me ask both Insha and Nick. Let's start with Insha. And I know that Nick was a political organizer, and it sounds like not much of the politics get past you either, Insha. So do you have some advice about how we hold together the coalitions, educate people, and so forth?
I couldn't have said it better than Judge Grant, who is exactly right. And New Jersey has been a masterclass in implementation for any kind of criminal justice reform, not just bail reform. It's been really, really impressive, and kudos to you all. I know it's a ton of work. I want to underscore one thing you said that I think is single-handedly the most important piece for public perception, which is talking to all the editorial boards and making sure that we get to them before the bail bond industry does, or others who want to undermine this effort, and give them the right talking points, the data, what other places have done and the success, as well as be their first point of contact when the terrible case happens, because it will continue to happen. Happen before bail reform, will happen after, and it's really how well set up are we for that backlash and to mitigate it and to be able to ride it out.
Totally agree with Insha, and I'll just add, I think the only, I think in Texas we saw an attempt to run a really insular process. I mean, this is not the first time we've had bail reform like being discussed. This is actually the counting this special, the 4th time, and I think the really run by the court administrators, and I think that we need like community groups and court administrators and justices. We need everyone to work together because we need each other to kind of beat back those really ugly narratives. And so I think that that's one of the reasons we need to work together, because I don't think that we're going to run a successful, meaningful bail reform that protects safety and communities without kind of that partnership. So.
And just to clarify, I know everybody probably knows this, but when Insha talks about the terrible case, she means the person who was let out, who then commits some kind of crime that becomes sensationalized, right? Okay. Annie, if you don't have questions, we have plenty more to do ourselves, but do you have any from the audience?
We have not received any questions from the audience yet. And as a reminder, the way that you can submit questions is by clicking the hand button at the top of your screen in order to raise your hand, and we can bring you into the video chat to ask your question, or to click on floor, and the floor chat will then go to everyone in the ballroom, and I'll be able to see that.
Well,
Paula, please proceed with the other question.
I assume that everybody is so impressed with our panelists that they just want to hear more and more and more. So let me ask the next question that we had prepared to talk about, which is a little bit about the evaluation and what kind of information is being collected, and how do we actually think about what would be what's essential in doing evaluation to be able to demonstrate that the system is working as it was intended. So let's mix it up a little bit. Let's start with Insha this time, and then we'll go to Judge Grant, and then Judge Burke, and then Nick.
Well, in New York, as the politics really took over from policy, one of the things that we didn't get in the bail bill was really good data collection. And I would say that that was part of our downfall in terms of fighting against backlash. Whenever I tell jurisdictions to look to good data collection, I point to New Jersey, where statistics are released every month by county on the number of people released, detained, if they're released, what level of supervision, with a whole lot more nuance and data even beyond that. And that's exactly the way to do this, so that when the backlash comes, when questions come about changing course, you can actually look to the facts and the numbers at a granular level. In part of the rollback, we did, in fact, get a better bail data collection provision put in place. And even besides formal data collection, which should happen, I do think it's the government's role to do so. Local organizations and nonprofits and research organizations can also fill that gap. My organization, Vera, is one of 4 organizations that's doing a 3-year, very rigorous study of implementation of bail reform, and importantly, looking to see its impact in smaller counties and more rural jurisdictions across New York State. Everybody's studying New York City. New York City does great data collection on its own, but most places actually don't look like New York City. Justice Burke, you talked about the jurisdictions that don't have any pretrial services set up, no infrastructure. What are they going to do? We're really curious about that, and how can we do bail reform well in those jurisdictions, because that's actually what most of the rest of the country looks like. The big cities are by and large doing fine. It's in the rest of the country that we need to focus our attention. And so we've released a couple of reports. We will continue to. You can check out some of that information and data on our website. But I am especially interested, and I don't think we've spent enough time focusing on how bail reform plays out, how implementation plays out in suburban and more rural jurisdictions. And that's just as important as the big cities.
Thank you. So, Judge Grant, I think INCHA may be being on your payroll as your advanced talking about how great New Jersey is. Is there anything you want to add in terms of the data collection in New Jersey?
No, I think, she did a great job. I don't think you can have a logical, responsive argument to these horrible facts that are going to be created, to the anecdotal incidents that are going to be, that will arise as a result of criminality in our states, in our counties, in our country, unless you have data. You really need to be armed with data to be successful in those arguments.
Okay, thank you. Justice Burke, anything you'd like to add?
Everything is local, and with 102 counties, we have to. Why I really am excited about the legislation and the fact that everybody collaborated is that it's a state requirement now that people have free trial. Mm-hmm. And therefore the data collection is important, and we can encourage, and we will get from all corners of our state the kinds of information we need. And if we have the buy-in of everybody, and you mentioned all the people, all the stakeholders of the justice system, well, actually, we in Illinois have also had some of the consumers of the criminal justice system sit on our committees. Mm-hmm. And they are really going to be the good voices for us. They're going to be upfront and present to the general public. I think some of those issues, how important it is to the people that are actually the users of these kinds of, when you come into the criminal justice system. So I think that the more we engage those users and former users involved in it and have them our spokespersons, and what they had to go through is important, and we're focusing on that too. But it's quite a task. I don't know if I'll be the chief judge at the end of this, but seriously, it's close to my heart, and we're going to get this done the best we can. And we're so glad to get this information from everybody. Appreciate
two comments. I'm sorry, 2 comments. I don't think Justice Burke is threatening to leave. I think her term is going to be here in some. And then, I think it's an interesting point in terms of evaluation is asking people who've been through the system, how would you evaluate what's an effective measure of whether it's working well? So I commend Illinois and Justice Burke for including those people. So Nick, what do you think about evaluation in Texas?
I think that Insha, I think everyone really covered it. It's like a necessary part of like protecting reforms that we do. There's robust data collection as part of the Harris County consent decree, and I think Vera's engaged in analyzing that. And everything has shown that bail reform is working. Public safety is maintained. Court appearance rates are the same. There's actually some evidence that things might be getting better in terms of some of those metrics. So I think the only thing I would like add is like going back to the previous question, like the data is necessary. It's not sufficient. I feel like we have to really get better in this era of bail reform across our country of controlling the public narrative, because the other side's getting very, very organized. And I think that they are threatening our progress in Texas and New York and elsewhere.
Thank you. Spoken as a true organizer. Annie, do you have any questions? I don't want to cut people off. No? Well, then we have one more, which is saving the best for last. Justice Burke has talked about this a little bit, but that's the cost of bond reform. And we talked a little bit about the fact that pretrial services actually need to be set up in some places where there have never been any before. And thinking about the cost of evaluation and thinking about the amount of money that's taken out of the system when cash bond no longer exists. So I'm curious, let's start with New Jersey, since they've had I think the longest experience here. Can you give a rough estimate of what you think it's cost the state to implement a good pretrial system?
The original bill provided for $22 million for the creation of a pretrial service program, another $10 million for the technological enhancements. At the time the bill was enacted, I told the legislation that was underfunded, that we really needed $45 million to run a true effective pretrial program. I was really proven right. The documentation, I'm just sitting here looking at Chief Justice Burke and saying we only have 21 counties. The number of counties that you have to try to do this is really remarkable, and we've got a statewide infrastructure, which you don't. But I think the idea of trying to bring the resources together still starts from that collaboration with the stakeholders. I think Mr. Hudson talked about the idea of looking at cost savings, not just from the idea of how many people you can reduce, how much you can not pay on commissary or healthcare benefits in terms of people in jail, but the real impact to the lives of the people that come in contact with our criminal justice system. That to me is the most significant piece. Don't lose housing, don't lose employment, don't lose custody of your children, don't plead guilty because you want to do a time served, don't have less of a chance of having a horrible sentence put in because we know that people who are held pre-trial are sentenced more severely than others. So there are tremendous savings that I argue represent the conscience of what we want in our community. Yes, we want serious people to be detained, but we also want to maintain that people who don't pose those risks have an opportunity to continue their lives as they go through that criminal process. And that's why I think it's very important. It's more about what kind of society we want for our counties, whether they're urban, rural, or suburban. What do we want for those counties? And this really is the important savings that you get. You are able to hopefully allow your communities to go stronger because of your successful efforts here.
That's a great point. And one of our big advocates, Sharon Mitchell, who's now the public defender of Cook County, has made the point that the cash bond money typically comes out of the pockets of the grandmothers, the sisters, the cousins, the brothers, and that's a real drain on an economy that is already fragile. So, Insha, do you have any perspective from the Vera studies about the cost?
I do, and one is that across the board where we've seen jurisdictions decarcerate, there have been savings because jail is by and large the most expensive criminal justice resource in a local county system. It is much more expensive to incarcerate somebody for a night than it is to provide pretrial services and supports. One fascinating piece of New York's bail reform.
Make you do 1 minute. Okay.
Yep. Yeah, of course. One fascinating piece is that there was no money allocated in the budget for pretrial services when the law passed. It was very much an unfunded mandate. What we've seen now a year and a half later is that counties have ponied up some money, and to the extent that they haven't, it actually really hasn't had that much of an impact on pretrial results. People are still coming back to court. Public safety rates have remained the same. And I think what it really tells us although it's early on, but I think it tells us that you actually don't need to do too much for people. People can be released, and court notification, which was written into New York statute, I know it's part of New Jersey as well as Illinois statute, that's really the thing that gets people back to court. So I think there's a real lesson here that less is perhaps more.
Thank you. That's very helpful. Nick, did you want to add anything quickly? We've got about 30 seconds before we close out.
Just one good thing in Texas, they passed a bill that would allow our Office of Court Administration to offer statewide text message reminders to all defendants in criminal cases. There's some more work that needs to be done to get urged local adoption, but that's I don't know, if you're looking for a little bit of a silver lining, there's one.
Well, I would say we have a big silver lining. I don't even see the storm clouds. But I think this has been a very informative panel, and what it tells us is that this institution, which has been with us for so long, is now being molded and changed, which is remarkable because we all know how slowly institutions, particularly government institutions, change. And I want to thank the people who have been on this panel, because you are the people who are moving along this change and are setting the example for the rest of the country in terms of how things can change. And I think many of the panelists have indicated that this is an institutional change, but it's also a change for communities and groups of people, individuals and their families. So we have to think about it on all the levels, that the change is really impacting for the better and making the criminal legal system really the criminal justice system in a way that justice is being put to the forefront of our work. So I want to thank our panelists. That you've been extremely helpful, very informative. I know you'll probably get a lot of emails and texts, people looking for more information from you. I want to thank Annie for helping to set this up, and the Civic Federation for all the work that they're doing to forward this cause. So I think we're done, and I thank you very much, and we can gather Lee off the stage. Okay?
Yes, thank you, Paula, for keeping us on time. And next there will be a 15-minute break, and Sarah Wetmore will be giving everyone directions about the next events coming up starting at 12:30 Central Time. So again, thank you, Paula. Thank you, everyone who participated in the panel.
Thank you.
Thank you.